Hi, my name is Mike Rutkowski, estate planning and elder law attorney here at the Rutkowski Law Firm. What are you doing in here?
Hey Dad, you're in my chair.
In your chair? I'm not giving up my chair.
Welcome to the Rutkowski Law Firm.
All right, Michael, in terms of estate planning, where do people normally start?
I've been doing this a long time and met with thousands and thousands of families. And the interesting thing is that the will seems to be the gold standard in estate planning. It's what everyone knows. And I don't know if it's TV or media that's taught us, it's history that's taught us that. But when you think of estate planning, you think most people come in our office asking for a will. They know what they want. They're like, I need to do a will. The interesting thing is, once we start talking about the differences between wills and trusts and what that all looks like, they're thinking that a will is a trust. A will accomplishes the things that a trust does. Like, number one thing, I want to keep it out of the probate court. A will, unfortunately, doesn't do that. A will is just essentially evidence of what the individual wanted during their lifetime, but we need to submit it to a judge in order for them to accept the will and make distributions according to that. There's lots of reasons why a judge won't follow a will. That's not the video here today. But what's interesting is that society has taught us that a will is estate planning, where estate planning is so much more just depending on what the goals of the family or the individual are.
So why won't a will keep you out of probate?
So again, a will must be probated. It must be submitted to the probate court in order to transfer your assets. Because from let's just ownership of property, let's just go there for a second. So when an asset is in your name individually, your house, it's in your name, a bank account, it's in your name. In order to transfer that to another individual, it has to be court ordered. Okay? So if it's in your name, you pass away, it now needs to be court ordered. So how do we do that? We have to go to the probate court to ask the judge to transfer. Now the next question is, who are we going to transfer it to? That's where the will comes in. The will is going to say who you want it to be transferred to. So the judge is going to look, is there a will? Okay, let's take a look at it. Was it executed properly? Is everything in check? Is anyone contesting it? Go through the checks of okay, are we going to accept this and distribute it according to that? Or if you don't have a will, there's something called intestate succession, which is essentially your state's will for you. So they will distribute it according to that. But the only way to get it into another person's name, if it's owned by you personally when you die, is through a court order. So does that make sense? That's where the will comes in. It's kind of like evidence of what you wanted to happen to your stuff if you pass away. So fundamentally, the trust is different in that it's not owned by you. It's owned by a trust, okay? So you don't actually pass away owning assets. If you did a good job, you pass away with no assets, your trust owns the assets. And then, so does the trust die when you die? You don't have to answer that, but the answer is no. So that's how a trust avoids the whole probate court, is because you've put in place a bunch of rules in that trust that are triggered when you pass away. As the grantor, which is just a fancy term for who created the trust is going to say, when the grantor dies, now do all these things. A lot of times it's distribute the assets to my kids or my spouse or whatever you chose to happen. But when you die, the trust doesn't die. But if an asset is in your name personally and you pass away, the only way to get that to another person is through the probate court, through a court order.
I think we all know where we like to start. We like to think we need to start at a will, and that's where we come in. At the end of the day, what we're asking for is a trust. And so it's very important to start learning that language. And I'm so grateful for you teaching us that. If you'd like to learn more about wills versus trusts and estate planning in general, please keep following along on our videos, or you're welcome to give us a call to see how you might get started in setting up your estate plan.